Hello, this is for ISOL 633. Textbook is Legal Issues in Information Security. This is for Chapter 7, Corporate Information Security and Privacy Regulations. And of course, this is for the University of the Cumberlands. So the chapter we will look at focuses on special security issues faced by publicly traded companies. Public companies must comply with a law that tries to improve corporate responsibility and stop fraudulent financial reporting. Rules and regulations created in response to the law impact information systems that process financial data. The rules require that these systems be reviewed to make sure that they appropriately control information security risks and threats to financial data. This chapter reviews why Congress created this law. It also reviews how the law influences information security practices. Finally, it discusses how this law affects other kinds of organizations. So the learning objective is to be able to describe legal compliance laws addressing public and private institutions. The things we'll look at for this chapter include how Enron scandal led to the security law reform, why accurate financial reporting is important, what the Sarbanes-Oxley Act, or SOX, is, what compliance and security controls are, how SOX, or Sarbanes-Oxley, influences other types of companies, and what corporate privacy issues are. So the key concepts we'll look at are Sarbanes-Oxley Act, compliance and security controls, corporate privacy issues, public and private companies, and influence of law on security practices. And when you complete the chapter, you'll be able to describe the differences between public and private companies, explain the history behind Sarbanes-Oxley Act, describe the main requirements of Sarbanes-Oxley Act, explain the role of the Public Company Accounting Oversight Board, describe how Section 404 internal control requirements impact information security, and discuss framework used to guide Sarbanes-Oxley internal control requirements. Enron, WorldCom, Tyco, Adelphia. These companies have come to represent a wave of corporate scandal that plagued America in the early 2000s. Each company engaged in varying levels of mismanagement, questionable financial deals, and accounting fraud. The activities of these companies shook investor confidence in U.S. corporations. They also tarnished the reputation of financial services professionals, such as analysts, accountants, and auditors. The Enron case has become part of American pop culture. Its name is synonymous with corporate greed and scandal. More than 10 years after the scandal, it continues to hold our attention. NBC aired a documentary in April of 2010 called Enron, the Smartest Guys in the Room. The Enron scandal inspired a musical called Enron, the Musical. The musical played on Broadway for a couple months in 2010. To the outside world, Enron was a very successful company. It required filings with the U.S. Securities and Exchange Commission, or SEC, showed that it was making money. It appeared to be able to translate its success in the energy markets to other markets. Financial analysts continued to recommend Enron stock. Investors continued to buy it. In reality, Enron was struggling. It lost billions of dollars on its international investments. Enron also started to face increased competition in the energy business. It began to lose its market share in energy futures contracts. This is because other energy companies started to use Enron's own strategies to become profitable. By the late 1990s, Enron was in financial trouble. It needed to raise money to meet its operating expenses. However, it couldn't do this in a way that would alarm its investors. It didn't want to alert investors to potential trouble. This could cause the stock price to fall. Maintaining a high stock price was important to bring in new investors. It also was critical to being able to maintain credit lines with banks. Enron executives engaged in a number of complicated financial transactions to hide its losses. Its chief financial officer, Andrew Fausto, created a number of affiliated companies. He hid Enron's losses in the financial records of these companies. The Enron CFO and other employees who worked with him owned many of these affiliated companies. They profited from these transactions between Enron and the affiliated companies. These transactions were very complex. They were complicated to understand because Enron often changed the names of its different divisions. They also moved assets back and forth between divisions. Many of these transactions violated traditional accounting principles. These principles were called generally accepted accounting principles, or GAAP, GAAP. They are the rules for accounting process. Accountants prepare financial statements according to these rules. These rules are designed to promote accurate accounting records. Enron also mislabeled loans they received from banks. It did this to hide the transactions on its own financial statements so that its investors would not know about them. By some reports, Enron borrowed about $8.6 billion from 1992 to 2001, hid these loans from its investors. During this time, Enron filed earnings statements with the SEC that misstated its financial position. The SEC filings were hard to understand. They also showed that Enron appeared to be making money. The fallout from the Enron case was enormous. Employees who had invested their retirement savings in Enron stock lost $1.3 billion. The accounting firm, Arthur Andersen, Enron's auditor, closed down. The U.S. government prosecuted many of Enron's top executives for their involvement in its business dealings. Some of these prosecutions were difficult because it was hard to determine which executives were involved in the fraud and which executives weren't. The complexity of Enron's financial dealings contributed to this difficulty. On December 2nd, 2001, Enron filed for bankruptcy. At the time, it was the largest bankruptcy ever. WorldCom bankruptcy surpassed it only 6 months later. In January 2002, Enron removed its stock from the New York Stock Exchange. CFO Andrew Fausto entered into a plea agreement with the U.S. government. He agreed to testify against Jeffrey Skilling and Kenneth Lay in exchange for a sentence of no more than 10 years in prison. In September 2006, a federal court sentenced him to 6 years in prison. He also paid more than $30 million in restitution. Fausto was released from prison in December 2011. Enron founder and CEO Kenneth Lay was convicted in May 2006 for fraud and conspiracy. He died of a heart attack in July 2006. The court vacated his conviction after his death. His conviction was erased because he died before he could appeal his conviction. Former CEO Jeffrey Skilling was convicted in 2006 on federal fraud charges. Federal court sentenced him to 24 years in prison. He appealed his conviction to the U.S. Supreme Court. The Supreme Court heard oral arguments in March of 2010. In June 24, 2010, the U.S. Supreme Court ruled that the government had improperly applied a law used to convict Skilling, sent the case back to a lower court. In June 2013, Skilling was sentenced to 14 years in prison. He has been in prison since 2006. His sentence will last until 2020. So why is accurate financial reporting important? The Enron scandal showed why accurate financial information is important. Enron was able to sustain itself for at least 5 years due to inaccurate financial reporting. During this period, financial analysts continued to recommend its stock as a good investment. The public and Enron employees invested in it. These people had significant losses when Enron's troubles became public and the company finally declared bankruptcy. Enron duped its investors. By the time anyone knew the truth, it was too late to recover investment losses. Investors lost confidence in large public companies. Public companies are required to file a number of financial disclosure statements with the SEC. These forms help investors understand the financial stability of a company. The most common file forms are Form 10-K, which is the annual report, Form 10-Q, which is the quarterly report, and Form 8-K, which is the current report. A company uses Form 10-K to file its annual report. Federal law requires that publicly traded companies submit these reports each year. Depending on their size, companies must file this report within 60 to 90 days after the end of their fiscal year. The larger a company is, the faster it has to file its report. Form 10-K is a very detailed disclosure of a company's financial condition. A company must fully describe its business within its 10-K disclosure. Must explain how it's organized and how it operates. Must provide its financial statements. These statements include a balance sheet, statement of income and cash flows, and statements of shareholder equity. An independent auditor must audit the company's financial statements. The auditor's report must be included in the Form 10-K filing. The CEO and CFO of a company must sign the company's Form 10-K. The majority of the company's board of directors also must sign the form. The SEC estimates that it would take a company 1,998.78 hours to prepare its annual 10-K filing. Form 10-Q is the company's quarterly report. Federal law requires companies to file these reports. They must file these reports after the end of each of the first 3 quarters in its fiscal year. These reports are usually less detailed than the end-of-year 10-K filing. Depending on their size, companies must file this report within 40 to 45 days after the end of each fiscal quarter. Companies must file the Form 8-K if they experience a major event that could affect their financial condition. Shareholders and investors should know about these events. Companies must file a Form 8-K with the SEC within 4 days of a major event. This period is shortened in some instances. For example, a company must file Form 8-K with the SEC immediately if it becomes aware of insider trading activities. Congress passed the Public Company Accounting Reform and Investor Protection Act in 2002. It's more commonly known as the Sarbanes-Oxley Act of 2002. It's called SOX or SARBOX in many resources. The act was named after its sponsors, Senator Paul Sarbanes of Maryland and Representative Michael Oxley of Ohio. It was passed in response to the corporate scandals like Enron, WorldCom, and Adelphia. SOX proposed extensive changes to the Securities Act of 1933 and the Securities Exchange Act of 1934. Congress passed the SOX reforms would prevent another Enron scandal. Main goal of SOX is to protect shareholders and investors from financial fraud. SOX increased corporate disclosure requirements. It also created strict penalties for violations of its provisions. SOX has 11 different rules. SOX supplement current federal securities laws. It applies to publicly traded companies that must register with the SEC. This includes international companies who trade stock on U.S. stock exchanges. SOX doesn't apply to privately held companies. Large public companies had to comply with all portions of SOX beginning in 2004. The SEC extended the deadline for smaller public companies several times for some of the more complicated portions of the law. It extended the deadline for the company's report on internal controls as required by Act 4 of Title 4. All companies' extensions have now expired. All public companies must comply with all SOX provisions. SOX is a very detailed act. It has many provisions, and the chapter focuses on parts of the act that have the most impact on information technology functions. When SOX was first enacted, many companies assumed that it didn't have any IT components. Congress didn't mention IT anywhere within the act. This opinion changed as companies began to review their SOX compliance requirements. Many SOX provisions require companies to verify the accuracy of their financial information. Since IT systems hold many types of financial information, companies and auditors quickly realized that these systems were in scope for SOX compliance. That meant that how these systems are used and the controls used to safeguard these systems had to be reviewed. The relationship between IT and SOX compliance continues to evolve. This section reviews the SOX provisions that have an IT impact. First, the section reviews the PCAOB. The PCAOB creates standards that auditors must follow when reviewing the activities of public companies. These standards help auditors determine the IT controls that they must review. Second, the section reviews SOX provisions that impact records management function. These provisions have an impact on IT operations because of the vast amount of data that's stored electronically. And SOX requires the executive management of a company to certify that there are controls in place to protect the accuracy of company information. This is the area where SOX compliance has caused the biggest challenge for companies and IT professionals. So critical sections of the Sarbanes-Oxley Act, they include Section 201, where services outside the scope of the auditor practice, Section 302, corporate responsibility for financial records, Section 404, assessment of internal controls, Section 409, real-time insurer disclosures, Section 802, which is criminal penalties for altering documents. Section 806, which is protection of employees exposing fraud. And Section 807, criminal penalties for defrauding shareholders. So the Public Company Accounting Oversight Board, or PCAOB. Prior to the creation of SOX, auditors and accountants belonged to a self-regulating profession. The profession is self-regulating when it creates and enforces its own rules of conduct. Federal and state laws place few oversight requirements on members of a self-regulating profession. An attorney is a common example of a member of a self-regulating profession. Attorneys must meet minimum state law requirements to become licensed. After that, their professional behavior is largely judged by commissions made up of other attorneys who enforce the rules of professional conduct. The profession itself determines what these rules of professional conduct should be. The PCAOB, or the Public Company Accounting Oversight Board, has 5 members. The SEC selected these members and appoints them to staggering terms. The SEC can remove members if needed. Members are to be individuals of integrity and reputation who have demonstrated commitment to the interest of investors and the public. They must be financially literate. This means that they must be able to understand financial statements. Only 2 members of the board are allowed to be certified accountants or CPAs. The remaining 3 members cannot be CPAs. Members of the board aren't allowed to have any financial interest in an accounting firm. One of the main functions of the board is to set standards for how auditors review public companies. It was created standards related to auditing, ethics, independence, and quality control. The SEC must approve its standards. The Public Company Accounting Oversight Board based many of its standards upon the generally accepted accounting principles. The Financial Accounting Standards Board, or FASB, establishes these principles. The SEC has recognized that the GAAP is authoritative and requires financial statements to be prepared in accordance with the generally accepted accounting principles. SOX Section 404 requires a company's executive management to report on the effectiveness of the company's internal controls over financial reporting. They must make this report each year on their Form 10-K filing. Under this section, management must create, document, and test the internal controls over financial records. After management makes its yearly report on those controls, outside auditors must review the report and verify that they do work. This section would cause complicated headaches for IT professionals. Under SEC rules, the internal controls over financial records are processes that provide reasonable assurance that financial records are reliable. And they provide management with reasonable assurance that financial reports, records, and data are accurately maintained, that transactions are prepared according to GAAP or generally accepted accounting principle rules and are properly recorded, and that unauthorized acquisition or use of data or assets that could affect financial statements will be prevented or deleted in a timely manner. The SEC requires that management use evaluation criteria established by recognized experts to review the company's internal control over financial reporting. Evaluation criteria helps to ensure that those reports are effective. The SEC has recognized only one specific framework that meets its requirements, and that is the COSO framework. That is the Committee of Sponsoring Organizations, that's the COSO, of the Treadway Commission first created its internal control integrated framework in 1992. Revised this framework in 2013. The framework is commonly called the SOCO framework. Many U.S. companies use this framework to assess their internal control systems. The 1992 version of the COSO framework didn't directly address IT or information security goals. The 2013 version of the framework recognizes that is also necessary to implement control activities over technology implementations. SOX Section 404 compliance isn't easy. Section 404 is very general about the types of ICFR that companies must implement. It doesn't give a good definition of what it is. It doesn't address IT controls at all. In 2007, the SEC issued additional guidance to help companies assess their needs during the Section 404 review. Did this in response to many complaints about the large scope of Section 404 review. Many of these complaints focus on how to address IT controls. The SEC stated two broad principles in its guidelines. Management should assess how its internal controls prevent or detect significant deficiencies in financial statements, and management should perform a risk-based review of the effectiveness of its controls. So the steps taken to meet the financial controls. First one, financial reports, records, and data are accurately maintained. The transactions are prepared according to generally accepted accounting rules and properly recorded. And then unauthorized acquisition or use of data or assets that could affect financial statements will be prevented or detected in a timely manner. So it's clear that management's review of an organization's internal controls must include a review of its IT controls as well. The ISOL framework doesn't specifically address the types of IT controls that an organization should implement. Organizations use many approaches to evaluate their IT controls. Some organizations follow the Guide to Assessment of IT Risk, or GAIT, G-A-I-T framework. Others use COBIT. Both of these frameworks appear to meet the SEC's requirements for a suitable evaluation framework. So assessing the internal controls in IT systems, again, can be difficult. IT professionals have a number of different frameworks that they can use for reviewing IT controls. You're already familiar with some of these frameworks. Many of these frameworks help companies decide which controls to implement. First one is COBIT. In 1996, the Information Systems Audit and Control Association, or ISACA, released the first version of the Control Objectives for Information and Related Technology, or COBIT. The fifth edition of COBIT was released in 2012. The ISACA has moved away from use of the term control objective. The most recent version of COBIT, however, it kept the popular term COBIT for the name of the framework. GATE, the Institute of Internal Auditors, or IIA, created the Guide to the Assessment of IT Risk, or GATE, series in January of 2007. The Institute of Internal Auditors updated it in August 2007 to reflect that the PCAOB's auditing standard number 5. The IIA, or the Institute of Internal Auditors, first created the GATE, or Guide to the Assessment of IT Risk methodology, to help auditors and companies comply with the SOX Section 404. It's created to help identify the controls where a failure might cause an error in the financial statements. The Guide to Assessment of IT Risk methodology helps auditors and companies scope Section 404 reviews of IT controls. It requires that companies must implement ICFR in IT systems. Like the SEC, these Guide to Assessment Risk advocates a top-down, risk-based approach to review IT controls. Next was the International Organization for Standards, or ISO, and International Electrotechnical Commission, or IEC, was created two standards that companies can use to implement information security controls. Two standards work together. One guides information security governance, the other reviews how to implement security controls. These standards are the ISO-IEC 2701-2013, Information Technology Security Techniques, Information Security Management Systems Requirements, and the ISO-IEC 27002-2013, Information Technology Security Techniques, Code of Practice for Information Security Controls. These provide a framework for creating an information security management system, and it uses a risk-based approach to review how information security is managed within an organization. It reviews the processes that managed teams must consider to operate, monitor, review, and maintain IT systems. The last one is NIST Computer Security Guidance. Some organizations turn to the National Institute of Standards and Technology, or NIST, for information security control guidance. NIST creates information security guidance for federal agencies. These agencies must comply with Federal Information Security Management Act, that's the FISMA. Many non-governmental organizations also use NIST publications to guide their own information security programs. There's our NIST special publications, security privacy controls for federal information systems and organizations. And it states that the minimum security controls organizations should use to create an effective information security program. So what does SOX apply to? It is publicly traded companies that must register with the SEC. It's also international companies who trade stock in the U.S. stock exchanges. It affects both large and small companies. So privacy and principal concepts. So corporate information privacy covers a number of issues. Since companies have a number of different kinds of records, they must approach privacy from many angles. Three major corporate privacy concerns are privacy of employee data, privacy of customer data, and privacy of corporate data. In general, employees have no expectation of privacy in their workplace. In most cases, this means that employers can monitor an employee's work activities. It includes monitoring telephone and email conversations. Employers can also monitor employee internet access and computer use. In most cases, it's best if employers give their employees notice that they're being monitored employees in this way. Employers also can monitor employees' workspaces and offices. They can use closed circuit television or CCTV or other video tools to do this. Like other types of monitoring, it's best if the employer gives notice about the monitoring. While the ability to monitor is broad, employers usually can't monitor locations like bathrooms, locker rooms, and employee lounges. Some courts have held that employees do have a reasonable expectation of privacy in these areas. Companies must protect certain types of information belonging to their employees. For example, if a company provides an employee health plan, it must keep some information private. Health Information Portability and Accountability Act, or HIPAA, requires companies to protect some information about employee health plans. A company with an on-site health clinic must protect employee medical records under HIPAA and state laws. Companies also must protect customer data. Some companies must protect consumer information in special ways. For example, the Gramm-Leach-Bliley Act, or the GLBA, requires companies to protect consumer financial information. Some states also have laws that require companies to protect personally identifiable information, or PII, of their customers. If the company suffers a security breach that compromises the personally identifiable information, then it must inform its customers about the breach. These laws are also called data breach notification laws. The purpose of these laws is to keep protecting people from identity theft. Finally, companies have their own internal records to protect. These records may contain data from the company's organization, finances, human resources, and legal matters. In general, a company's directors and officers always have the ability to see all company records. In a small company, the owner has this right. They also can enter employee offices to review records. They have the ability to do this in the regular course of business. This is because they are responsible for the business and its successful operation. So privacy in the workplace. Again, law generally allows organizations to monitor employee conduct, protection of proprietary information, and they also can maintain privacy of customer information. So in summary, Congress created the Sarbanes-Oxley Act in response to scandal. It passed the SOX to help improve investor confidence in publicly traded companies. SOX places rules on public companies and other organizations. These rules promote trustworthy financial reports. The scope of the SOX extends to any public company functions or processes that impact financial reporting. The scope of SOX within a company is very broad. SOX requires that companies review many information technology processes to make sure that they're trustworthy. The scope of SOX is broad. Its influence extends even to organizations that aren't required to follow it. For example, private companies and nonprofit organizations may choose to follow SOX to show their commitment to good governance. Thank you.